European Union has the European Data Protection Directive. Under the directive, it says you cannot transfer data outside of Europe unless the receiving country is deemed adequate by Europe. In other words, they think that their privacy laws are sufficient to protect the data in a manner consistent with European privacy laws. Guess what? The US is inadequate. In that regard, our privacy laws are not deemed as adequate, but we have lots of company around the world. India, China, most of Latin America, all of Africa, yeah, essentially most of Asia, with the exception of, I think, Hong Kong and Japan, are deemed inadequate at this point. So now you're a company like Yahoo or Google or Microsoft or Sun, or you are, say, Unum here in the audience, and you're trying to engage those services. All of a sudden you've got an issue, right? Because you may not know where the data is flowing. And if you're pulling data from Europe and sending it somewhere, you know, it might be going to the US, it might be going to Canada. Canada's adequate. It might be going to India. That's inadequate. How do we balance those things? And European regulators have not really actively enforced yet, but they've certainly made a lot of noise about this issue, and they've said, we don't like it. We don't like it at all. We don't like this idea that data can just flow somewhere and nobody knows where it is, and we don't know if we have jurisdiction or not. So, who in the audience has worked on a provision in an agreement to talk about this when it comes to technology services? Where the data flows, what data center it might go to, how you manage that. Andy? Oh, you have. So, Tech, can you tell us anything about it?
Oh, you're going to call me out?
Yeah, no, totally. Yeah, this wasn't a poll.
That's right. In my past life, my company evaluated migrating from a hosted email solution to go into the cloud, and a couple of the leading providers, which is not uncommon in smaller scale organizations, but a little bit of a stretch for larger, is Google, as an example, and there are companies here in Greater Portland who basically use Gmail as their primary means of collaboration tool systemically. The company I was with at the time has a European operation, has Asian operations, has US operations, and so it's a great tension when you're looking at a provider, and I use Gmail as an example, but there are other providers. Microsoft offers the same kind of service, and some other providers. It's a great challenge to exactly address that issue about, well, if I have data moving in and out of the EU, how is the backplane infrastructure of that company situated so that we don't run afoul of European laws? And then, you know, wondering the same question you raised, well, where exactly are your data centers? Well, you don't really want to tell me because that poses some kind of security risk for you, but you know, is it in Belarus? Can you at least tell me it's not in Belarus? And it's very intractable. We'll talk a little bit about the cloud in a little more detail in the next panel, but the challenge with that is, in the end, the scale of the cloud, the value of the cloud is delivered because it's not customizable in many respects, and so it's really a kind of take it or leave it because it's not.
So this is a great tension to highlight, and one of the challenges that many of you may have in reviewing contracts with cloud providers is that it is kind of a take it or leave it environment. The asymmetry of that negotiation is quite pronounced. You can imagine it from the other side as well. Justin's here from Yahoo. You can beat him up during the break, but in that conversation, a Yahoo, a Google, a Microsoft, a Sun, an Amazon for their marketplace services and their Rackspace services, they're going to say to you, wait a minute, no. We can't negotiate 40,000 customers individually. This is our boilerplate provision on this. You take it or you leave it. And that's a challenging negotiation. Justin.
I was just going to point out, from a practitioner standpoint, it is just as likely you are negotiating a clause out of a proposed contract as writing one in. Right. And in many, many jurisdictions, there are legislative proposals to mandate local storage of information that are driven by governments, who, from a human rights perspective, want to preserve access to users' data under no due process access rights. Right. So the notion of contracting a specific jurisdictional restriction also often has human rights implications from a law enforcement perspective. So there are multiple reasons why not only the technology and the need to duplicate data to facilitate speed, so you can't even negotiate one, even if you negotiated 5 jurisdictions, that's a little closer than just purporting to identify one single location. It's a concurrent location situation. But there's many, many public policy reasons why you would not want such a limitation, because that then provides a basis for perhaps a regime that your client doesn't want to have access to certain information, maybe seeking to mandate in law a provision requiring it be locally stored in, I won't even name the country.